The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello, and welcome to Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, Director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Thursday, September 30th, 2021. Before we begin the show, I want to speak to any law students who may be listening, especially those anywhere close to Chicago. On Saturday, November 6th of this year, IJ will be holding what we call a legal intensive in Chicago. It's a version of our annual law student conference, but held on location. If you come, you'll learn about IJ cases and how to be a public interest lawyer. You'll also have the chance to engage with IJ attorneys, including Diana Simpson, who is here today on Short Circuit. So if you're interested, you can apply online, but you must do so by October 5th. So if you're listening to this in the few days after this episode is released, you still have some time, but you need to move quickly. We'll put the link in the app to the application in the show notes, or you can find it online if you search for Institute for Justice, Legal Intensive, and Chicago. Diana, anything you want to add about the Legal Intensive?
Just that it's a really exciting day that you get to spend kind of just deep into what IJ does and who we are and just a deep dive into it. And the word intensive is a good use, is a good word here. But it's a really great day, and I'm really looking forward to it. And I hope to meet some of you guys and talk with you about all things IJ.
Well, great. Well, I hope some of you apply who are listening, who are law students. And now on with the Federal Courts of Appeals. In a famous Monty Python sketch, the Bishop of Leicester is found dead. The church police are brought in, and they pray for divine guidance on who the killer is. The hand of God appears and actually points him out. The killer responds, "It's a fair cop, but society's to blame." In response, the police say, "Agreed, we'll arrest them instead," and proceed to arrest everyone else. Last week, the Ninth Circuit reviewed a district court opinion where the district court judge kind of did the same thing. In a case concerning the plight of the homeless on Los Angeles' Skid Row, the judge ordered the city and county of LA to do all manner of things to make up for countless past wrongs, going way beyond what the actual plaintiffs were asking for. As you'll find out, even for the Ninth Circuit, this societal-wide fix was a little much. IJ senior attorney Jeff Rose will tell us about a judge who perhaps was a bit too engaged. Welcome, Jeff.
Thank you, Anthony.
Also, we had so much fun on last week's show with Mike Chase, the author of How to Become a Federal Criminal, that we're having a repeat from that show. But as you just heard, it's not Mike who will be joining us, but even better, IJ attorney Diana Simpson. So this week, Diana is going to describe something that doesn't sound especially exciting, a case about insurance contracts. But don't let that scare you away, as the opinion written by the Sixth Circuit's Judge Sutton is a great window into how insurance works and how the pandemic has gone way beyond what a lot of people were insuring for. So, Jeff, both you and Diana have litigated on behalf of homeless people. You've spent time with homeless people, and you know a lot more than most of us about the incredibly complicated issues that lead to homelessness. So tell us about this case, about what both the district court and the Ninth Circuit did, but also with the background of what you know, what is your take on what this judge was trying to do?
Sure. So, litigation 101 is that you file a complaint, you get the evidence, and then you file a brief saying to the judge, here's why we went under the evidence. And what we have here is the exact opposite. So the judge ruled on the basis of claims that were never pled, on the basis of evidence that wasn't in the record, and on the basis of arguments that nobody made. And so in that regard, this is actually the 100% money-back guaranteed Platonic form of judicial activism. And we'll dig into that. So this case was brought by the LA Alliance for Human Rights and 8 individual plaintiffs, sort of a broad and unusual coalition of business owners and ordinary citizens and formerly homeless people, some disabled people. And they were basically trying to challenge the fact that Skid Row in Los Angeles has descended into complete anarchy. That the sidewalks are clogged with tents, that it's a intense nexus of crime, there are rampant social dysfunctions, and they decide that they're going to sue the city of Los Angeles. So they had several claims, including the state-created danger doctrine. In other words, that the government wasn't doing enough to enforce criminal laws. It was leaving people mired in these dangerous conditions and not rescuing them. They also had claims under the Americans with Disabilities Act that the sidewalks were so cluttered that two of the plaintiffs in wheelchairs, couldn't navigate the streets. They had some claims under the California welfare law that require general assistance and medical aid, and were arguing that this required the state to house people. So what happens? They seek a preliminary injunction on some of their claims, and the judge issues a sweeping opinion based not on the claims that are pled or on the evidence in the preliminary injunction record, but on the judge's conclusions about the effects of structural racism, that the homeless people are predominantly African American, and that African Americans as a whole are disadvantaged because of, historical zoning discrimination in lending, freeway construction that segregated their neighborhoods and prevented integration, the use of eminent domain to eliminate black housing, that kind of thing. And all of this was done on the basis of extra record evidence that the court obtained through its own research. And so then the court issued a preliminary injunction saying there's racial discrimination going on here, that African-American families have been broken apart, and that the homelessness is partly a consequence of things like that. And so it issued a sweeping injunction, told the city to put $1 billion in escrow, and gave them 180 days to house everybody. Whereupon the city and county filed an emergency appeal to the Ninth Circuit, which promptly reversed in surprisingly gentle and diplomatic language. Although reading between the lines, you could tell that the panel was not pleased with the way the judge approached this. And the basic nutshell was that, first of all, virtually nobody had standing because they hadn't pled any of the claims about structural racism or anything like that. And that they hadn't made these arguments. And so the court can't grant relief based on claims that were never pled and arguments that were never made. That's just litigation 101. And then for the one claim, for example, the Americans with Disabilities Act claim, they said that there are, the two people who are in wheelchairs actually have standing for that, but their preliminary injunction motion kind of just fails on the merits, that the problems with the sidewalks aren't big enough. They're not systematic enough for that to be a problem. So I think the big picture here is a kind of a procedural picture, which is that the judge thought that there was a problem, and there clearly is a serious problem. And the judge said, you know what? None of the claims, none of the arguments, and none of the evidence will solve this problem. So I'm going to do it on my own. In effect, I'm going to file a shadow complaint, make shadow arguments to myself, and then grant sweeping relief based on my own complaint and my own arguments. And the Ninth Circuit said you just can't do that. And so I said earlier that this is a sort of judicial activism in the purest sense, because this really is a decision that is completely unmoored from the claims, from any arguments, or from record evidence. And so, you joked at the beginning, Anthony, that maybe this judge is a little bit too engaged, and perhaps so engaged, in fact, that it kind of collapsed into a singularity and wound up somewhere on the other side with complete judicial activism.
One of the things I find interesting about this particular situation is that the district court has itself created a due process problem that didn't exist before by granting relief on claims that weren't pled by the plaintiffs. By doing that, the defendants aren't really on notice. They don't have the ability to defend against those particular claims. And so it's interesting that, of course, they grant all of these, or the district court grants this PI based two of the claims on due process, but doesn't recognize that what it is doing also violates due process. And so it was interesting to read. And when the district court PI decision came out back in the spring in April, I remember reading this and just being absolutely floored by it and not understanding. I mean, the court ordered $1 billion into escrow to house people. Like, homelessness is an endemic problem to humanity. It's always existed. It's always going to exist. And that's tragic. And, people should be trying to find solutions to homelessness. But throwing money at the problem, and the court also ordered the county and city of LA to stop selling all of the properties that they had for sale so that they could reevaluate whether any of those could become housing for the homeless. Whatever can be done to fight homelessness, I don't know that ordering an enormous municipality to just throw a lot of money at the problem is going to actually do it. And then, one of the interesting things that I kind of chuckled at was footnote 4 in the opinion at the Ninth Circuit that said only 22 of the 411 footnotes supporting the district court's factual findings included a citation to the record. And the idea of litigating in front of a court that just kind of makes it up as it goes along is terrifying, to be quite honest.
Yeah, and I think that's right, Diana. That whatever the issues are in homelessness and whatever steps we can take with constitutional litigation to address that, this decision really embraces a kind of naive, blunt force approach. That if you just tell the government to put money in a bank account and to create houses, that people will be rescued from the streets. But in fact, there are as many reasons for homelessness as there are homeless people. And most homeless people are not homeless simply because they don't have a home. They're homeless because they have serious addiction issues, mental health issues, economic issues, and those can't be quickly remedied by this sort of injunction that the court issued here.
The interesting background about the injunction that I saw from the opinion is that the judge really, at first, it seems in the case, really took it into the court's hands to get the parties together, have settlement conferences, try to figure this thing out, because it does sound like this Skid Row problem in downtown LA is absolutely crazy bad for everybody. I mean, everyone agrees this is bad. It's not like the homeless are happy to be there and that it's them versus the business owners. Everyone wants to solve this problem. And so the judge really tries to bring everyone together, but of course finds out what I'm sure the LA City Council and all kinds of lawmakers has found out over the years, is that this is an incredibly hard problem to address, and then just, has a YOLO moment, it seems, right, and tries to figure it out in one swoop.
Yeah, I think that, having litigated some homelessness cases, that, one of the underlying issues here that's important for people to understand is that these pervasive camps on public sidewalks and in public places are in part a result of the fact that the government has outlawed private social entrepreneurship when it comes to helping the homeless. So, for example, we have a case down in Wilkes County in North Carolina where some folks have been running a small homeless shelter for decades. They had to move, and they had to apply for a special use permit to be able to operate their homeless shelter at a new location that was given to them by a dentist. And the Board of Adjustment bent over backwards and found 1,000 crazy reasons why the homeless shelter can't exist there. And so so there are people who are going to be homeless or are going to be suffering from homelessness. They're going to be on the street and they're going to be visible. And nobody's going to say, part of the problem here is we have all these intensely restrictive zoning laws, and we give the government all kinds of opportunities to deny people the opportunity to use their own private property and their own social entrepreneurship to help the homeless. So in LA, for example, if somebody wanted to use their private property to create a safe, regulated tent community on private property away from residences and away from businesses, that would never be permitted. And what the county would say is, oh yeah, you want to house 40 people a night? Come back to us when you have $10 million and you can construct a completely new building. Until then, these people will all exist on the sidewalk. And that's something we're trying to address at the Institute for Justice.
And you could see the judge, it's somewhere in the background, the judge kind of got that, because there's all talk about, I haven't read the full district court opinion. It is a behemoth. But it talks about how there's been, racism in the past with zoning, going back 100 years. There's been of course, the building of the freeways. That's a well-known story in a lot of American cities about how minority neighborhoods were cut in half or destroyed by building freeways. And so those were individual private rights-based actions. So cutting off your property rights, denying your property rights, your chance to contract with someone to build better housing for people that were done in the past. And so if you brought a case like that now, say a case like the ones that you guys are talking about in North Carolina that you mentioned, Jeff, or other ones, where you say, I want to build a homeless shelter. I just want to build low income housing. It's not zoned properly. I think it's unconstitutional, maybe for past discriminatory reasons, maybe just straight up property rights reasons. I want to build this housing for people. That would be denied. And in fact, it would be denied because courts don't take property rights very seriously these days. But it also might be denied because you say, I'm trying to address this the societal-wide problem. And the court would probably say something like, look, you building a few units on this one lot is not going to address homelessness across all of LA County. That's a huge problem, and it drop in the bucket. And so perhaps you don't even have standing to try and address that, right? Unless you're a homeless person who actually wants to live in that building. And yet now the judge tries to address it all at once, perhaps knowing that problem is in the background. But if you try to address the problem all at once, one, as Diana says, a lot of this is not probably going to address the problem with huge amounts of government spending. But two, even the parts that maybe are going to address it, it's beyond what anyone has a chance to bring. So for these problems, you can't address it in one way because of standing. You can't address it another way because of standing or addressability or what have you. And so because we've cut out the actual real claim here, which would be, I want to build on my property and you won't let me, there's no way for the courts to address the problem. And I think some people would say, well, that just shows, judges shouldn't be making law and they shouldn't be addressing these. And I think we would say instead, if you take the Constitution seriously little by little, then individual people can exercise their actual property rights, their contractual rights to try and address this society-wide problem everyone recognizes is a big deal.
Right. And I hadn't realized, not being from LA, I hadn't realized that Skid Row is more than 50 blocks in LA, which is just unfathomable to me, just how large that is and how grand the problem is. And it's interesting because the Ninth Circuit had a case a few years back now that basically said that municipalities can't criminalize sleeping in public if there is nowhere else to go. Which means that homeless people can't just be ousted and then sent to jail if there is literally nowhere for them to go, that violates the Eighth Amendment. And it's an interesting decision. And so that's always in the backdrop of all of these homelessness cases nationwide, but particularly within the Ninth Circuit. And so on the one hand, you've got, you can't just oust everyone on Skid Row and say, all right, you guys are gone, or you'll go to jail. But you also can't really just throw money at the problem to try to make it go away. Yeah.
I mean, I think that, one of the underlying intuition, and maybe it's not just an intuition, the underlying reasoning that the judge had that a lot of our endemic social problems are the result of decades of bad government policy. Like there's there are strong arguments for that in all kinds of ways and various opinions about how to address it. But one thing is for sure, and that is that zoning laws across the country are primarily now, at least when it comes to residential zoning, are primarily about economic sorting. And with the overriding principle that property always has to go up in value, it can never stay the same, it certainly can't go down. And so what that means is there's a strong bias towards only allowing the type of housing that is likely to get worth more and more money. So anybody who has an innovative solution, anybody who has a solution that departs from the standard kind of 3-2 single family home or departs from, kind of the modern standard of, let's build a kind of glitzy apartment building that has like a pool and a workout room and all that kind of stuff. If you want to do something different than that, You cannot legally do it. And if you challenge the laws, the judges will pour you out with like deep belly laughter, at which case, as soon as that's over, everybody will scratch their heads and start saying, how on earth are we going to find affordable housing? We have an affordable housing crisis. Meanwhile, the zoning laws don't allow anybody to build affordable housing.
Right. And meanwhile, Skid Row is still there.
Yep.
And I'm sure it will still be there the next time we talk about these issues. But I thought it's really good to get both of these lawyers on here today who actually have spoken with homeless people and tried to solve their problems in a property rights-based solution. And so it's great to have had both of you speak to that. So a different problem is this ongoing pandemic, which thankfully now most people are able to go to restaurants and restaurants are able to serve folks, especially, of course, if they're vaccinated. But for some time, that was not true. And that was not true of one particular restaurant in Ohio who thought, well, maybe they could make a claim on their insurance because this whole pandemic fit the language of their insurance policy. It turns out not so much. So, Diana, what happened to this? What sounds like a nice little restaurant, a family restaurant, and then what did Judge Sutton have to say about it all?
Yeah, so Santo Suosos is an Italian restaurant in Medina, Ohio. And like most restaurants, Santo's was hit very hard by COVID. So in March 2020, the governor of Ohio had declared a state of emergency. And then a few days later, the director of the state health department ordered restaurants to close their doors to in-person diners. So Santo's could still offer takeout, but most of their business is in-person dining. And so it ended up sustaining significant losses and had to lay off a lot of employees. So Santo's filed an insurance claim under its commercial property insurance policy, which was then denied. And Santos sued, asking basically to just get the payout so that they could continue on in business. And so the insurance policy that they had reimburses lost income if the restaurant lost that income due to a business suspension caused by direct physical loss of or damage to property. And so the policy a lot of the language of the policy is in the opinion, as one might imagine. But the policy basically applies to risks of direct physical loss. And then there's a separate provision later that that the insurance company has to reimburse for business income lost due to the necessary suspension of its operations if the suspension was caused by direct physical loss of or damage to the property. So, does a pandemic-triggered government order barring in-person dining at a restaurant count as direct physical loss of or damage to the property? Well, the answer is no, according to the Sixth Circuit. And so the policy doesn't define these words. So the court has to resort to kind of some of the more traditional canons to figure out exactly what the policy covers and whether this is within that. So it first turns to the OED to understand the common and ordinary meaning of each of these words. And so basically, the restaurant wasn't tangibly destroyed. There was no concrete deprivation of the building. The restaurant still owns the property. They own everything inside of the space. They can put every square foot of the premises to use. They just can't do it for in-person dining. And so this policy covers fire damage and water damage, those kinds of things. And I think the key quote to me was, a loss of use simply is not the same as a physical loss. And then it gives this example that if a driver drops his keys into Lake Michigan, sure, that's a loss of the keys, but it's only a loss of use of the car. And that distinction is what really drives the conclusion here. And so the court then, even after looking at just the words, kind of bolsters its opinion by looking to the other terms in the policy that it says reinforces the conclusion. And so the lost income only covers the period of restoration, which ends when a property should be repaired, rebuilt, or replaced. And you can't repair, rebuild, or replace anything to resume in-person dining. And so then it goes through the traditional uses of commercial property insurance. It cites an Ohio State decision talking about an insurance policy and whether that covered mold growth. And the Ohio court issue there said no, because the mold didn't affect the structural integrity of the house. So there was no physical loss to that property. And then it goes through the canon against surplusage and et cetera, et cetera. And then the court mentions that there's these exclusions that it won't even rely on. And the exclusions seem pretty clear that they would exclude this kind of activity too, because Acuity will not pay for loss or damage caused directly or indirectly by any virus capable of inducing physical distress, illness, or disease. It does. The court says that that's for somebody else to figure out how broad the word indirectly works there. And that Acuity also won't pay for losses caused by an ordinance or law regulating the use of any property. So, sorry. And it's interesting because I felt like the decision was a lot longer than it needed to be. It seemed like they really hit the conclusion at page 5, but then took another 7 pages. It was over 12 pages total. And they just layered these multiple reasons and rejected multiple arguments. And it was an interesting kind of approach to me, because this seems like a pretty routine case, and one that probably in other circumstances might have been an unpublished decision, as opposed to a 12-page published Judge Sutton decision. But my speculation is that the panel this whole situation just stinks, and the panel feels badly about it and wants to, make sure that the parties feel heard. I don't know. I'm just speculating.
And I think also that's exactly right. So the intuition here is this poor guy is running his restaurant. He's paid his insurance for years. And if somebody had crashed into it and burned it down, he not only would have gotten a new restaurant, but all the time he was closed until he could reopen again, he would be compensated for that, because loss of use related to the destruction of the property was insurable. And so, from that person's perspective, he's like, my whole business is shut down and I've lost all this kind of stuff and I've been paying my premiums for years. And now this fat cat insurance company is telling me that they won't come to my rescue, which is exactly what insurance companies do. And so the intuition is understandable, and this really is an unfortunate thing. But, I think the panel did a published opinion, because if they did an unpublished opinion, that might signal, well, this guy's particular facts weren't quite enough, right? Like what the Sixth Circuit, I think, wanted to do is say, we need to kind of put our foot down right now so we don't have 1,000 such cases coming from every restaurant in Ohio or something like that.
Yeah, because, almost every restaurant in the country, in most states at least, probably has some kind of claim like this, potentially, on whatever insurance contract they have. Most have some kind of insurance contract. And so they're all thinking, well, is this worth it? Would I bring the claim? Because I'm sure most insurance companies are doing the same thing.
Right. And not just insurance companies, or not just restaurants, but everything, every business that closed down. And of course, the whole premise of insurance is that we insure a lot of people on the understanding that only a small number of them will ever have an actual problem that we have to compensate them for. But if you had a rule that said, everybody in the economy has a claim against their insurance company, I think the Sixth Circuit recognized that would destroy it. And it also said, let's just remember that insurance is a thing where you make a decision to insure against certain events. We insure against car crashes. We don't sort of insure against rare events or particularly exotic or unusual events. Maybe people will in the future.
Or they could even now, right? I mean, before this, I'm sure there was some insurance policy somewhere that they could have obtained that covered the most minute possibilities, and you would pay through the nose for that, I'm sure. But businesses just made business decisions that, we don't want to pay through the nose and have all of our money go to insurance costs. I'd much rather, be able to use the money to improve my business and so on. And so we'll just do kind of the basic insurance needs, and, that's it. And unfortunately, there's this hopefully once in a lifetime pandemic that has really just screwed up a lot of people's plans.
And in the conclusion, I like how Judge Sutton puts it, that leaves a hard reality about insurance. It is not a general safety net for all dangers, which is unfortunately often the case. I really liked description of the ordinary language that you mentioned, Diana. And this comes from in a prior life, I litigated about insurance contracts and often read them in my legal work before IJ. And if any of you out there have ever read in your insurance contract, perhaps your fire insurance for your home or a homeowner's insurance or your car insurance or some other policy that you have, as the court says, they are not written in the common and ordinary language, even though that's what the case law says you're supposed to read them in. And so they define all these different terms in all these different ways of a million definitions. And then you have to kind of do math and like putting the different definitions in different places and figuring out what it means. And I think maybe part of the reason that they went into so much in this opinion is because, insurance contracts are complicated, even if it's pretty obvious at the beginning what's going to be covered and what isn't. So they try to put that puzzle together. Yeah, and you ask at the beginning for those who have looked at their insurance policies or whatever. I suppose we all glance at them, but if we started a club for all the people who actually read and understand them, that national club could all convene in a phone booth. And some of the most exciting people would be in that phone booth too. Yeah. So, Judge Sutton is also just sort of acknowledging the reality on the end of the insured, which is, you get this, multi-page document. It's completely impenetrable. It's impossible to really know what it means. And you just sort of cross your fingers and hope, which is why, undoubtedly the plaintiff in this case, the restaurant owner, was thinking, well, surely somewhere in there's got to be some word that will cover my situation. But alas, it's not the case. Well, I think we can bet in the future that people will be buying more pandemic insurance, and also that the rates for that insurance will be quite a bit higher than they used to be. I do know you can buy asteroid insurance. I think it is a thing. It's pretty cheap. But, I don't think any human has ever been killed by an asteroid, so it might not be terribly popular. It has in fact happened. A human has been killed by an asteroid? I know There's been property damage. Yeah. But no, it has in fact happened. But it's clearly a rare event, and perhaps more relevantly, it's not the insurance companies actually like big visible events. So even though sometimes it costs them money, like I hate to say this, like if an earthquake happens and there's or a hurricane and there's a couple of $1 billion worth of damage, sure, the insurance companies have to cough up, but that is a visible event that makes everybody go out and buy more insurance. And I think you're right that we'll have pandemic insurance being marketed and people will start buying it. Well, I think we just learned that we're going to have Jeff on again sometime to talk about asteroid law and the history of asteroid laws, yes, because that sounds intriguing. I do know that a couple of people have indeed been struck, and certainly asteroids have hit the ground and caused massive explosions at different points throughout history that have killed people. Well, it's too bad too bad the dinosaurs didn't have insurance. But yeah, that's a good point. Anyway, well, thank you both for coming on. Two of the foremost experts on property rights and the problems of homelessness and other issues at IJ. I'm really glad they were both on to talk about the first case and the issues of homelessness. I hope you guys learned a little bit about your car insurance. And to everyone else, I'd ask that you always, as always, get engaged.